All right, Courtney, you're all set to go.
All right. Hi, everybody. I'm so grateful for you spending your time with me today. My name is Courtney Abrams. I am a workplace employee side employment attorney. So I only represent employees. I don't represent the corporations or your employers. And I'm here to talk to you today about your rights in the workplace vis-a-vis your medical condition. As I was thinking about this, I thought to myself, chronic illness, and specifically, I'm sure lupus, presents one of the most trickier areas of law for lawyers on the employee and employer side. And I think this is made trickier by the fact that reasonable accommodations, so the things that your employer grants to you to make your workplace easier for you to navigate with your medical condition, are highly specific to the individual employee's experience of his or her medical condition. That said, as a California employee, you are entitled as a matter of law to a reasonable accommodation or accommodations, plural, for your medical condition. So that's under the California Fair Employment and Housing Act, which requires employers of 5 or more employees to provide accommodations for individuals to perform the essential functions of their jobs, unless, and this is sort of the caveat, unless it would create an undue hardship for the employer. That said, if you cannot, with reasonable accommodations, perform the essential functions of your position, then that's another conversation. But because it can be difficult to understand what you're entitled to as a form of workplace accommodations, I wanted to provide you with a non-exhaustive list to start. There are others that aren't on this list, but reasonable accommodations can include and are not limited to a change of your job duties, providing leave for medical care. So if you need to take time off of work, either to be in the hospital or be at home to recuperate, reassigning you to a less rigorous and vacant position. And in that regard, you have priority over employees who do not need accommodations, working from home, working virtually either part-time or full-time, relocating your work area, providing you any type of mechanical or electrical aid, job restructuring, which may include, the reallocation or redistribution of non-essential job duties in a job where you have multiple responsibilities, providing a part-time or a modified work schedule, and permitting the alteration of when and or how an essential function of your job is performed, or modifying an employer policy. So there's more on that list, but that's just some examples of things that you can request from your employer as a means to help make your life easier as you navigate your workplace with lupus. So I wanted to briefly cover what undue hardship means, because if your requested accommodation imposes an undue hardship on your employer, that is a defense, i.e. it's a legally permissible way for the employer to say, no, we can't do this. So undue hardship means an action which would require significant difficulty or expense incurred by the employer when considered under all the totality of the circumstances. So if your employee, and it's the employer's burden to say this, so if your employer says, getting this special chair for you would create this huge expense. We're a really small company. We don't have the means to do this. If you look at our balance sheets, at the end of the day, this just would tank the company. That obviously would be an undue hardship, although I don't see how a ergonomic chair would create such an undue hardship, but that's just sort of a hyperbolic example. And one thing I did want to say and point out, and I don't think this is, I think this is the rare case, but where there's a quantity standard or a quality standard. So for instance, you're supposed to create 10 widgets a day as an essential job function. An employer is not required as a reasonable accommodation to lower that kind of standard. but it may need to accommodate the employee to be able to reach that standard of 10 widgets or whatever you're producing a day. I think this is the rare occasion for employees who need a reasonable accommodation. I rarely encounter clients with a quantity or quality standard. But that said, your employer cannot take a my way or the highway approach with respect to your requested accommodation. So a lot of times I get clients who say, Courtney, I provided my medical certification form. I said, this is what I need. It could be this or this or this. And the employer just threw up its hands and said, no, we're not doing this. So that would be illegal for an employer to just take this my way or the highway approach. Like you either do your job or you don't get an accommodation. So an employer is required to consider any and all reasonable accommodations of which it is aware or of which it's brought to its attention by the employee, except again, if they create an undue hardship. But that said, let's say you bring them 4 options for an accommodation and you say A, B, C, or D, your employer does have the right to select and implement an accommodation that's effective for both the employee and the employer. So if A and D would both work and the employer says A is easier for us, then it can select A. Reassignment. I often get asked the question, can I be reassigned as part of my reasonable accommodations? And reassignment is permitted by the employer if the employee can no longer perform the essential functions of his or her position, even if there's an accommodation. So your employer is permitted to say to you, look, we've tried all these different accommodations, none of them are working, you still can't perform the essential functions of your job. We'd like to reassign you to, a different position. Are you amenable to that? And that's a legal question. If there are no funded or vacant comparable positions for which you're qualified with or without the reasonable accommodation, the employer can reassign you to a lower paid position. But I do want to emphasize, given all of that information, that it is illegal for your employer to retaliate against you or harass you for requesting accommodations or fire you, which would be discrimination. So this includes becoming mad at you or subjecting you to false criticism. So I often hear cases where an employee comes to me and says, I was doing great. I had great performance evaluations. I was, it was smooth sailing as I was going through my tenure with this employer, but all of a sudden I asked for a reasonable accommodation and I started getting these outlandish criticisms. That would be a form of disability-based harassment because they're not real, it's false and it's fake, and they're using it as a reason, presumably, to make up a reason to fire you. So other forms of harassment that I've seen can include excluding you from group communications, outright berating you for requesting accommodations, gossiping about your medical conditions with other employees, etc. So it is illegal, I want to repeat, illegal in California to discriminate or harass or retaliate against an employee for requesting workplace accommodations. That said, I think that employers are getting more sophisticated about hiding it. So I think it's particularly important for you to document all of your requests for reasonable accommodations and, to be really timely and submit your medical certifications when requested, and always just comply with the requests from the employer, provided that they're legal requests. They're not, delving into your medical condition and asking you very private details. But you really want to continue to try to be the perfect employee if you can, and not give them some kind of excuse to, fire you, even though it would be a made up excuse. And I, I get a lot of questions about what an employee can or cannot, or an employer can or cannot ask an employee. And as a general rule, an employer cannot ask an employee about the nature or diagnosis or the severity of your condition. But that said, and I'm going to talk about this in a second, because we have a bunch of questions from the group about this. That said, I think as a general rule, honesty where possible is the best policy, making sure it's documented. So I'm going to use this to sort of as a segue into the questions from the community. We have about 9 questions, and a few of them are a little bit duplicative, so I'll try to combine them if possible. The first question is it better to notify HR instead of my boss if I don't want to discuss my illness with my boss, but need workplace accommodations? Can HR act as a go-between? And I would say absolutely. You should be discussing it with HR. HR should be your first point of contact, and you don't need to discuss it with your boss. I think, again, it's maybe makes sense to say to your boss, if you're comfortable, although it's not legally required. I have a chronic medical condition called lupus. It causes me extreme pain. It causes me extreme fatigue. This is not all the time, but it does happen when I have flares. I will be approaching HR to discuss reasonable accommodations. But again, that's not necessary. That's not legally required. And if you're not comfortable with that and you think your boss harbors some kind of hostility towards people with medical conditions or disabilities, I would say don't even bother. And HR should act as the go-between. And I find that there are problems, like most problems arise when there is not a competent HR department to help employees navigate these situations. The second question is, if my manager doesn't believe me when I say I have a flare or gives me a hard time, should I notify HR? And yes, absolutely. In fact, I think you should continue the conversation on an ongoing basis with HR. And when you have a flare, that conversation should be with HR. I don't think you need to involve your boss, especially if you feel like he or she is going to give you a hard time. When you're experiencing your flare. So, but again, everything should be in writing. And you need the interactive process, which is the process by which you and your employer come to an agreement about what accommodations will help you perform your job. That's a two-way street. So it always needs to be some kind of communication between you and the HR department. The third question is, what should I do to protect myself if I have an unexpected lupus flare? And I think that goes along with the first question, which is you need to put it in writing. You need to put it in writing early and often. And if, for instance, I know this is a very different example, but I suffer from severe migraines. So I often get what's called an aura ahead of time. So I sort of feel like it's coming on, and sure enough, it usually is. So if there's any type of indicator that allows you to give as much notice as possible, I know with lupus, they often are truly unexpected. But if you have any type of indicator, I would say try to warn your employer ahead of time. And in that same vein, work with them to say, I feel like I'm about to experience an unexpected lupus flare, or I am experiencing an unexpected lupus flare. I know I have this project due for you by the end of the week. Would you be okay with the following extension? And try to work with them so that you're still making an effort to perform the essential functions of your job. Because when they're able to prove that you aren't able to perform the essential functions of your job, that's when they're able to either reassign you or, God forbid, terminate your employment. So that's what I would say. And 4 says, what steps should I take at work if I get hit with an unexpected lupus flare? So I think that's the same thing as what you should do to protect yourself. 5, the 5th question is, who should I request work accommodations from, my manager or HR. And again, I think it should always be HR. You can copy your manager, but it should be in writing to HR, and you could reference your initial medical certification from your doctor or rheumatologist and say, dear so-and-so, I'm experiencing really extreme fatigue and pain this morning as a result of my lupus. As we've previously discussed, one accommodation is to be able to perform my duties on a modified work schedule so that when it subsides, I perform them in the evening, or I perform them all towards the end of the week or over the weekend. And make clear that you are still intending to do what's expected of you, but you are availing yourself of the work from home option or the work from your bed option, etc. The sixth question is, if I need to sit down during work hours due to joint pain, does my job have to accommodate or provide a chair for me to do so? And I would say absolutely yes. I can't imagine, I'm sure there's some circumstance where maybe a chair wouldn't be a reasonable accommodation, but in no universe can I imagine an employer in this day and age not being able to provide you a chair to sit down in. Perhaps if you are a farm worker or you're in the fields, maybe that doesn't sound reasonable, but even then that sounds reasonable to me. The seventh question is, how do you request work accommodations legally for a chronic illness issue? So some employers have their own forms that they like you to fill out. These forms, don't assume that they're legal just because it's an employer-based form. I have seen huge companies ask inappropriate questions or illegal questions on these forms, like to describe when you were hospitalized, where you were hospitalized. Those are all legal questions, illegal. But I would say, ask your employer, how do I need to get this? What do I need to do to get this process started? And then follow their internal policies and procedures. There's no one way. You can put your employer on notice of your need for accommodations verbally or in writing. I always say writing is the best policy, but any way that you feel most comfortable doing it and you think you're going to have the greatest chance of success. 8, do I have to disclose my illness to my employer? No, you don't. If you're not comfortable doing that, you don't need to. But that said, I think that with an ongoing chronic illness like lupus or breast cancer or any type of cancer that I've had clients experience, it's always, it leads to greater chances for success for a workplace accommodation to be honest and open and disclose the actual underlying illness. So the employer understands why you're asking for what you're asking for and the purpose of your request. Unfortunately, there are far too many employers out there who believe that if you ask to work from home, it's simply a way to get out of doing your job duties, which of course is not true. But I think that if you disclose, hey, I have these really intense periods of fatigue, I need to be able to lay down or at least be reclined while I'm working, because of my underlying medical condition, you make more headway. Your employers are presumably human, and you want to be able to, have a good working relationship with them. And, it's never good when the employer gets suspicious or believes that you're malingering. So as a practical matter, I think it's best to disclose your condition. As a legal matter, you don't have to. And 9 is the same question. Do I have to disclose my illness to my employer if I'm asking for accommodations at work? And the answer is, again, no, you don't have to. But I do think it makes for an easier process between you and the employer. And I think that ends the questions from the community. And I really enjoyed talking to you all today.
Thank you so much for joining us, Courtney. We really appreciate your time.
Yeah.
And if anyone's interested in learning more about Courtney's practice or asking additional questions, her information is in the post link.
Thank you so much, Free.